Script. Kash Patel froze. There is a moment in that hearing room that nobody who was present has been able to fully explain. Ted Lieu did not stand up and argue. He did not introduce a document. He did not cite a statute or reference a filing. He picked up a remote control, pointed it at a screen, and pressed play. And what came out of those speakers? A journalist, a safe, and a story about what Jeffrey Epstein allegedly kept hidden inside, produced something from the director of the Federal Bureau of Investigation that 5 minutes of direct questioning had not produced before it. Visible hesitation on questions that should have had straightforward answers. I have been through the full transcript of that exchange. Every question, every answer, every moment where Patel moved sideways instead of forward. And what I found when I mapped his responses against the publicly documented record of the Epstein case is not complicated once you see it laid out completely. 3 questions, 3 non-answers, and a pattern so consistent across all 5 minutes that by the end of it, Ted Lieu stopped trying to get answers and did something more significant. He put the inability to answer on the record as evidence in itself. This is what actually happened in that room. And this is why it matters more than the clips circulating online are capturing. If breakdowns like this are useful to you, the ones that go past the surface and into what the transcript actually shows, subscribe right now and turn on notifications. I read every page, I pull every exchange, I translate the evasions into what they actually mean for the people involved and for the country watching. Subscribe. Let's get into it. Start with who these 2 people are, because the context of that exchange is everything, and you cannot understand why those 5 minutes landed the way they did without understanding what each person brought into that room. Ted Lieu represents California in the House of Representatives. Before he entered politics, he was a JAG officer in the United States Air Force. A military lawyer? Someone who spent years in a system where the person across the table is expected to know the facts of their own case, and where evasive answers are not a communication style. They are a problem. He prosecuted cases in that system. He reached the rank of colonel in the Air Force Reserve before retiring in 2021. He holds degrees from Stanford and Georgetown Law. He sits on the House Judiciary Committee, which is where this exchange took place during Patel's second consecutive day of congressional testimony. That background is not incidental. Lieu is not a politician asking general oversight questions hoping for a usable clip. He is someone who has spent a significant portion of his career in rooms where clarity is the standard and ambiguity is a tell. When Patel said he did not know something, Lieu heard that differently than most people in that room. He heard it the way a prosecutor hears it. Not as an honest admission of uncertainty, but as a choice. A decision made in real time about what to confirm and what to leave unconfirmed on a congressional record that does not go away. Kash Patel is the director of the Federal Bureau of Investigation. That title changes the standard for every answer he gives in a hearing room. When a lower-level official says, "I don't know," regarding a detail in an obscure case, that is one thing. When the director of the FBI says, "I don't know," regarding one of the most scrutinized criminal investigations in recent memory, involving years of public examination across multiple administrations, sealed records, international attention, and sustained allegations of incomplete disclosure, every uncertainty carries weight that it would not carry anywhere else. Patel walked into that room as the person ultimately responsible for the Bureau's investigative decisions and its public credibility. That is the position from which he gave the answers he gave. Now the exchange itself, because this is where it gets real, and I am going to take you through it the same way I went through it in the transcript, moment by moment, answer by answer. Paying attention to what was said and what was not said, and why the gap between those 2 things is the actual story. Lieu started with the basics. The FBI searched Jeffrey Epstein's Manhattan residence in 2019. Patel confirmed that. Among the items found was a safe. Patel said he did not have the catalog of evidence in front of him. Stop there, because that answer is the foundation of everything that follows, and it needs to be examined on its own terms before moving forward. The director of the FBI is testifying before Congress about the most publicly discussed case under his oversight. The New York Times reported on the safe and its contents on July 28, 2019. That is not obscure information. That is front page news from the moment the charges were filed. It was discussed in every major outlet. It was part of the public record of the case from the beginning. And the director of the bureau that conducted that search said he did not have the evidence catalog in front of him. Lieu pressed. The FBI found a safe, correct? Patel said he would accept Lieu's representation. Not a yes. Not a confirmation based on his own knowledge of his own agency's search. He would accept the congressman's representation of what the FBI found. Inside that safe, agents discovered a collection of photographs. Same answer. I'll accept your representation. I don't know. That pattern, I'll accept your representation. Establish something critical before Lieu even got to his main questions. A director who accepts a congressman's account of his own agency's evidence catalog is a director who either has not reviewed this case closely or has decided not to say so on the record. In either case, the effect in that room was the same. It set a baseline of uncertainty that Lieu was about to use against every subsequent answer Patel gave. Then Lieu pressed play. Michael Wolff is one of the most recognized journalists in Washington. He is best known for Fire and Fury, his account of the first Trump White House. He is also the journalist who, by his own account, spent more time with Jeffrey Epstein before Epstein's arrest than any other reporter. Wolff estimates approximately 100 hours of interviews conducted over several years. He has released portions of those recordings publicly. In one of them, Epstein describes Donald Trump as his closest friend for a decade. These recordings are not secret. They are not obscure. They have been discussed openly in major outlets for years, and they represent the most extensive on-record account of Epstein's world that exists outside the FBI's own files. The clip Lieu played showed Wolff describing a specific moment from his time with Epstein. Epstein went to his safe. He produced a series of photographs. He spread them out and showed Wolff what he claimed they contained. Lieu paused the clip. Then he asked Patel directly whether there are any photographs showing Donald Trump with individuals connected to Epstein's operation. Patel said no. Lieu asked how he knew. Patel said that information would have been brought to light by multiple administrations and FBI investigators over the course of the last 20 years. Lieu stopped him. That is just not true, he said. No one knew about the birthday message Trump reportedly sent Epstein until the Wall Street Journal disclosed it. When it came to light, it was the Epstein estate that provided it to Congress, not the FBI. Patel's response was 4 words. You raise a great point. Hold on to those 4 words, because they are the most significant thing Patel said in those 5 minutes, and they received almost no coverage afterward. He had just argued that 20 years of investigation would have surfaced any significant material. Lieu gave him one specific documented example of significant material that had not been surfaced by the FBI and came to light only through outside reporting and estate disclosure. And rather than defending his argument, Patel agreed with the counterexample. You raise a great point, is not the language of someone confident in the completeness of his agency's review. It is the language of someone who just had his own argument turned against him and chose acknowledgement over defense. That exchange mattered because it was not abstract, it was operational. It established on the congressional record that the FBI's 20-year investigation had not surfaced at least one piece of significant material that an outside entity surfaced instead. And the director of the FBI confirmed that was a great point rather than contesting it. Lieu moved to the tapes. Has the FBI subpoenaed the tapes that Michael Wolff conducted of Jeffrey Epstein? Patel said he did not know. Would it be good for the FBI to interview Michael Wolff? Patel said he could not say they had not already done so. He just did not know. He would get back to Lieu with a specific answer. The director of the FBI does not know whether his bureau has made contact with the journalist holding the most extensive on-record interview archive of Jeffrey Epstein in existence, not whether the tapes contain anything significant, not whether the legal pathway to obtaining them is straightforward, whether contact has been made at all, with a journalist whose recordings have been publicly discussed for years. In the most scrutinized investigation the Bureau has touched in a generation. I don't know. Lieu moved to the estate. He noted that the birthday message had come from the estate, not from the FBI. He asked whether the FBI should subpoena the estate for everything it holds. Patel said the estate is under no obligation to provide that material, even pursuant to a subpoena. Lieu stopped him. That is just false, he said. You are the FBI. You can subpoena the information from the estate, and you should do that. Patel said that is literally not how it works. Lieu said he was moving on. That disagreement did not get resolved in the time available. But the stakes of it are not complicated. If Patel is right, the FBI has no enforceable path to materials the estate holds that it has not voluntarily disclosed. If Lieu is right, the FBI has had that path for years and has not used it. One of those two things is true, and the director's response, that the estate has no obligation, rather than any affirmative commitment to pursue the question legally, left the room without resolution and put that unresolved disagreement on a congressional record where it now sits permanently. Lieu closed with the client list. Patel had confirmed in earlier testimony that a list of names connected to Epstein's operation existed. Attorney General Bondi had confirmed the same. Earlier in 2025, Bondi had told reporters the list was on her desk and under review. A subsequent DOJ memo concluded there was no client list in the way the public had imagined it. That contradiction had never been cleanly resolved. Lieu had two names. Is Prince Andrew on the list? Patel said the material related to Prince Andrew had been made public. Is Prince Andrew on the client list? Patel said the FBI had released the index of names. Is Donald Trump on Epstein's client list? Patel said the index had been released and the index would speak for itself. That is not an answer. It is a path around one. The index was not what Lieu was asking about. He asked about two specific names and whether those names appear on a list the FBI director had already confirmed exists. A yes or no question. Twice. And twice, Patel directed the answer toward a document rather than answering the question directly. If the answer is no, that is one word. Patel did not say it. Lieu closed his time by telling the committee that it was a significant red flag that the FBI director could not say whether Donald Trump was on the Epstein client list. The chair called time. Now, I want to be precise about what those 5 minutes established and what they did not establish, because conflating those two things is how coverage of moments like this goes wrong. What the exchange established is specific, and it lives entirely in the transcript. Patel said photographs of the kind Wolf described do not exist, and then in the same exchange confirmed that the FBI had not surfaced at least one significant piece of material that outside reporting surfaced instead. Patel said he did not know whether his bureau had made contact with the journalist holding 100 hours of Epstein recordings. And Patel declined to answer yes or no when asked whether two specific names appear on a list he had already confirmed exists. Those are not accusations. They are the answers the director gave under oath. What they suggest about how thoroughly the Bureau has pursued the available evidence is a question Lieu put on the record. Patel's answers are there alongside it. What the exchange did not establish is equally important to say plainly. It did not prove the photographs exist. It did not prove the FBI failed to pursue the tapes. It did not prove that either of the two names Lieu asked about appear on the list. It produced visible hesitation and documented non-answers on questions that should have had straightforward responses. That is significant. It is not the same as proof of the underlying allegations. The defense of Patel's answers is a real one and deserves engagement rather than dismissal. An FBI director testifying in an open congressional session about an active investigation cannot always confirm sensitive material publicly. There are legitimate reasons why certain answers cannot be given in that format, even when the person testifying knows the answer. Operational security, ongoing proceedings, classified information, source protection. Any of those constraints could produce answers that look evasive from the outside while being genuinely constrained from the inside. That defense is worth holding. What makes it incomplete in this specific context is the nature of the questions themselves. Lieu was not asking Patel to reveal classified sources or describe operational methodology. He was asking about publicly documented material, a safe that was reported in the New York Times in 2019. recordings that have been publicly discussed for years, an investigative step, contacting a named journalist that does not require classified authorization to confirm or deny. The constraint defense works best when the question touches sensitive information. It works less well when the question is about whether anyone called a journalist. Here is what the pattern across those 5 minutes actually looks like when you map it against the full transcript. I'll accept your representation. I don't know. The index will speak for itself. 3 phrases repeated across 5 minutes attached to some of the most direct questions asked during Patel's entire 2 days of testimony. Each one technically responded to the question asked. None of them answered it. And the consistency of that pattern across 3 separate lines of questioning is what the hearing actually produced. Not a smoking gun, not a confession, a documented, consistent, repeated choice to move sideways rather than forward when the questions became direct. By the end of the exchange, Lieu had stopped trying to extract specific answers. He had shifted to something different. He was putting the pattern itself on the record. The closing statement about a significant red flag was not an argument about any individual question. It was an argument that the inability or unwillingness to answer clearly had itself become evidence of something. Not evidence of the underlying allegations, evidence of a posture toward those questions that the committee and the public now had on record, regardless of what came next. That is a difficult position for any FBI director to be in publicly, especially on a case where public skepticism has existed for years, where every unanswered question immediately generates 10 more, and where the standard for the person at the top of the bureau is not, I don't know, but I know what my agency has done and I can account for it. Patel never fully established that standard during those 5 minutes, and that is why the exchange spread so quickly after the hearing ended. Not because it produced a revelation, because it produced something that audiences register immediately and intuitively, regardless of politics or legal expertise. A senior official asked direct questions, giving answers that were not direct. That dynamic does not require a law degree to understand. It requires watching someone be asked yes or no and answer with the index will speak for itself. 3 questions, 3 non-answers, and a record that now includes all of it permanently. The questions are there. The answers are there. The gap between them is there. And that gap is not closing on its own. Subscribe if you want to be here when the next filing drops, when the next hearing produces the next exchange, when the next document surfaces, the next question that should have had a simple answer and did not get one. Hit the bell, turn on notifications. I will be in the transcript the same day it comes out. The tape played, the room went quiet. The answers that followed are now part of the permanent record. I will be here when the next question gets asked.